Due to some reason, my lord, our names were not reflected, my lord, in the cause list. That is why we missed the item, my lord. My lord, it may kindly be reflected, my lord. I pray for that. My lord, I've taken the consent of the other side as well.
Any other prayer?
My lord, may it be fixed on the 30th of May, my lord, because the conducting council for the respondent, my senior comes from Delhi, my lord.
So Lordship, part-heart matter may kindly fix it on 30 and I'm on interim Lordship, so interim will continue Lordship.
Okay. Heard, Mr.
Yeah, Borough, yes.
My lord, P.R. Sharma,
For the petitioner,
for the respondent, my lord.
heard Mr. A. Borua, learned counsel for the petitioner. Also heard Mr. P.
R. Sharma,
P.R. Sharma, learned counsel for the respondent who submits that whose name has not
my lord, my name and my senior's name, P.R. Sharma and N. Das. We have
The
filed our wakalat number, but it
name
is
of
not.
the counsel for the respondent, namely P.R. Sharma and Mr.
N. Das.
N. Das has not been reflected in the cause list, and praise for reflecting their name in the cause list as one of the counsel, engaged counsel, namely Mr.
N. Das.
N. Das is a outstation lawyer. Learned counsel for the respondent has also prayed for an adjournment on the ground that their names were not shown there, and therefore they were not aware. No, therefore they could not be ready with the case today. Learned counsel for the petitioner does not opposes the prayer. With consent from both the sides, let this case be listed again on 30th of May.
As a part-heart.
As a part-heart matter, the interim order shall continue till next day.
Highly
Master
obliged,
Lord.
my lord. Highly obliged.
May I please Lordship, Lordship, I beg to mention item 2.
Item?
Lordship,
Yes.
matter may adjourn for the devil. Please after 2 weeks.
Why?
Lordship, my senior lives in the court for personal difficulties.
Heard Mr. What's your name?
A. Hussain.
A. Hussain, learned counsel for the petitioner, submits that his senior, who is the conducting counsel of this case, namely Mr. J. I. Bordhuya, has some personal difficulty and therefore prays for an adjournment. Considering the submissions made by learned counsel, the prayer is allowed.
Lordship, date will fix.
Let this case be listed after a week. You are on interim? No. No motion. Mr. Okay.
Motion is fixed.
After a week.
Item number 1. May it please your Lordship.
This is the 438 application. But I'm the registered owner of a vehicle and my vehicle was apprehended by the police. Driver was arrested, but the vehicle was transporting 11 numbers of cafe matter. I will find the FIR at page 10. Subsequently, the driver was arrested and your Lordship was pleased to.
Thank you. Thank you. Yes, at page 10.
Page 10, my lord. So this is the, I'm the registered owner of the vehicle AS02DC 3348. This was intercepted by the police, my lord. And subsequently, the driver was arrested and this honorable court was pleased to release him on bail, my lord. I will find the bail order at page 21. Now, I am the owner of the vehicle, my lord. But there's an apprehension that the police may arrest me because the driver was arrested, my lord. I'm willing to cooperate with the investigation.
Why you are apprehending it?
My lord, I was the owner of the vehicle. I got a Zimma order. We could not annex the Zimma order here, my lord. I got a Zimma order for the vehicle. But when we went to the police station, my lord, so the police is insisting that you will also be treated as an accused in the case. And driver was already arrested.
But they have not arrested you.
Not arrested, my lord. But apprehension is there, my lord.
If they have not arrested, then there is no apprehension.
No, my lord, they have made it very clear that you are likely to be arrested.
Okay, they have informed you.
Unofficially, my lord.
Yes, Mr. Bashir, let him appear.
No.
Or you, because custodial detention may not be necessary. Heard Mr. S. Nawaz, Lamet counsel for the petitioner, also heard Mr. K. Bashir, London additional public prosecutor. This application under section 438 of the Code of Criminal Procedure, 1973, has been filed by the applicant petitioner Noor Hussain, who is apprehending his arrest in connection with A3PS case number 42/2024 under section 379/411/34 of the Indian Penal Code, read with section 11 within bracket 1 within bracket A, small a, within bracket small d, and small e of Prevention of Cruelty to Animals Act 1960, read with section 13 within bracket 1/16 of the Assam Cattle Preservation Act 2021. The gist of accusation in this case, where is the bail order, earlier bail order?
My lord, at page 21.
Gist of accusation in this case is that on the basis of an FIR lodged by, where is the FIR?
FIR page 10, my lord.
On the basis of an FIR lodged by one Kamal Bora, UBC 795 of Khetri Police Station before the officer in charge of Khetri Police Station on 24/3/2024, inter alia, alleging that one vehicle bearing registration number AS 02 DC 3348 was intercepted and was found carrying 11 numbers of cattle on the said vehicle, a K3PS case number 42/2024 was registered. Learned counsel for the petitioner has submitted that at the time of interception of the aforesaid vehicle, the driver of the said vehicle was apprehended, and later on he was granted bail by this court by order dated
Page 21.
24/2024, passed in bail application number 1124/2024. Learned counsel for the petitioner has submitted that. What is your role in the alleged offense? What is your stance?
My stand is that, my lord, that was my driver, my lord, who had, without my information and without
Okay.
my knowledge.
Learned
tried-
counsel for the petitioner has submitted that the driver of the vehicle submitted that the present petitioner is the registered owner of the seized vehicle, that is vehicle bearing registration number AS02 DC 3348, and it was driven by the driver who was apprehended at the time of seizure of the said vehicle. It is also submitted by learned counsel for the petitioner that the driver of the said vehicle had carried the cattle without any information to the present petitioner, and the present petitioner was not aware as to the fact that his vehicle was being used for carrying seized vehicle as carrying the 11 numbers of cattle. Stop. It is also submitted by learned counsel for the petitioner that in the meanwhile, the interim Jimma
In terms of the vehicle.
of the vehicle has already been granted to the present petition. And he apprehends that when he approaches the police for taking the Jimma of the said vehicle, he may also be arrested in this case. It is also submitted by learned counsel for the petitioner that in the meanwhile, the driver of the vehicle has already been granted bail. And as the petitioner is ready and willing to cooperate in the trial, there may not be any necessity for his custodial detention. On the other hand, learned additional public prosecutor has submitted that perusal of the case diary would be necessary for consideration of the instant bail application. Hence, call for the case diary fixing.
Very good comment.
After 2 weeks.
2 weeks.
After 2
30.
weeks.
Independent.
28 May for case diary. However, in the meanwhile, considering the submissions made by learned counsel for the petitioner, as well as considering the fact that the co-accused has already been granted bail by this court, the above named petitioner is hereby directed to appear before the investigating officer of Khetri PS case number 42/2024 within a period of 10 days from the date of this order and cooperate in the investigation. Stop. If he does so, within the stipulated period of time, in the event of his arrest in connection with Khetri PS case number 42/2024, the above named petitioner shall be allowed to go on interim bail of ₹30,000 with one surety of like amount, subject to the satisfaction of the arresting authority with following conditions. Condition number 1 and 2. Let this case be listed again on 28th May.
Deeply obliged. Your lordship heard the matter on the last occasion. Your lordship kindly see the detailed order passed by your lordships.
What was the issue here?
My lord, the arrest was made. My lord, I was named in the FIR, but in the charge sheet, there was no material. Therefore, my lord, I was not sent up for trial.
Okay.
Now, my lord, since I was the owner of the vehicle, my lord, I filed an application before the court for release of my vehicle, that was
When
not
you
done.
went, you were arrested
and then I was arrested. And the law is,
on the basis of the 164 statement.
my lord, and that, my lord, as your lordship has seen, if you want to go for further investigation, you must take leave of the court. The
Yes.
Supreme Court has made that position very
You
clear.
have, on the last occasion, you
Exactly, my lord.
have shown some.
Now, they were supposed to place the case diary before your lordships, whether they made any application.
Case diary is there.
CD part is not there, but lordship, we get the LCR. LCR, the entire part was there. In the spirit, and there I have flag marked the relevant position also. There now the lordship, the question was that, as stated by my learned senior, the question was that he was arrested on 4th of this February 2024, and after he was then on the 5th, it is moved for this made prayer by the IO for recording of the statement of under section 164 CRPC. Now, lordship, when he has been forwarded, he was forwarded on 4th, lordship. That order was there. It is clearly stated in the order that the CSS already been search sheet was submitted.
But charge sheet, he was not named.
Not search sheeted.
Not
It is
charge sheet.
not
He
search
was-
sheeted. I have also flag marked that part also. It is
Okay.
clearly stated that not search sheeted. His name was not search sheeted in the part.
Now, then
Now, lordship, only the question is that as per as part of the law laid down in the Binay Tyagi's case, that is the prior permission of the court is necessary regarding for the further investigation. That part is only there. Now, lordship, the question is that when he was forwarded
no,
before the
then why he was arrested without further investigation?
lordship, because they get some materials.
What materials?
There is the evidence, 164 evidence
But
that was.
that was after his arrest. If I am not wrong.
Yes, very correct.
But on the same date, that prayer was made, Lordship.
No, okay, but that was on the basis of evidence collected during investigation,
Yes,
you could not find anything against him. That was the submission.
Yes.
Therefore, in the charge sheet, he was shown as not sent up for trial.
yes.
Or
yes.
not charge
Not
sheeted.
charge-sheeted, not charge-sheeted, Lordship.
So unless there is, now, I'm not clear on this. Whether further investigation, he can be roped in under 319, or whether further investigation can also bring him again.
My lord,
Not,
your lordship will see that he is not charge sheeted witness. The witnesses which they want to show now, they are showing that it is an extrajudicial confession. So in that circumstance, what will happen? They will have to adduce additional evidence. So therefore, my law is very emphatically clear. I'll just read that paragraph of Vinay Tyagi. My learned friend possibly could not catch it up. There cannot be any other argument on this. Paragraph 49, my lord, that judgment is with your lordships.
just judgment below.
2013, my lord, 5 SCC 762.
Yes, yes.
Your lordship, come to paragraph 49, page 793.
There are 49.
49. It reads like this, the lordship got that, my lord. 49.
Yes.
Now we may examine another significant aspect, which is how the provision of section 173(8) have been understood and applied by the courts and investigating agencies. It is true that though there is no specific requirement in the provision of section 173(8) of the code to conduct further investigation or file supplementary report with the leave of the court, the investigating agencies have not only understood but also adopted it as a legal practice to seek permission of the courts to conduct further investigation and file supplementary report with the leave of the court. The courts in some of the decisions have also taken a similar view. The requirement of seeking prior leave of the court to conduct further investigation and or file a supplementary report will have to be read into and is necessary implication of the provision of section 173(8) of the code. Now, my lord, this has been made emphatically clear that if you want to go for further investigation, there must
Prior
be a leave,
permission. Leave is necessary.
my lord. That application will be filed before the court. The court will go into it. It's up to the court to whether to reject or accept the thing. Now here, my lord, that exercise was not done at all. Now, my lord, it's a total flouting of law as, my lord, given by the apex court. And now your lordship, to that extent, my lord, I will take your lordships to a decision of Privy Council way back on 1936. The lordship has said in the last occasion also, my lord, they gave that judgment. My lord, that is the case of Nazir Ahmed. In that case, my lord, it's a case of confessional statement under section 164. The magistrate is required to ask the accused that you are not required to say. If you say that, it will be taken into consideration.
Which para you are relying?
Yes, your lordship may see at
Para number.
para, my lord, at page 5. In the
To
middle
do
part,
a
your lordship,
certain thing in a certain manner.
the matter to be considered from there, in the middle portion
Okay.
of page 5. The matter to be considered and decided is one of plain principle and first importance, namely, is such oral evidence is that of the magistrate, Mr. So-and-so. It was said that for the respondent that it was admissible just because it had nothing to do with section 164 or with any record. It was argued that it was admissible by virtue of section so-and-so of the Evidence Act, just as much as it would be if deposed by a person other than a magistrate. It was also said that with this argument, the lordships agree that if the oral evidence was admissible, then section 91 of the Evidence Act requiring evidence in writing did not apply, because the matter would in such a case not be one which had to be reduced to writing. For the appellant, it was said that the magistrate was in a case very different from that of a private person, and that his case and his powers were dealt with and delimited by the Criminal Procedure Code, and that if this special act dealing with the special subject matter now in question set a limit to the powers of the magistrate, the General Act could not be called in and in it, so to allow him to do something which he was unable to do or was expressly or impliedly forbidden to do by the special act. The argument was that there was to be found by necessary implication in the Criminal Procedure Code a prohibition of that which was here attempted to be done. In other words, that the magistrate must proceed under section 164 or not at all. To these contention, it was answered that there was no ground for reading the word may in section 164 as meaning must on the principle described in so and so, so and so. There is no need to call in aid this rule of construction, well recognized in principle, but much debated as to its application. It can hardly be doubted that a magistrate would not be obliged to record any confession made to him if, for example, it were that of a self-accusing madman, or for any other reason the magistrate thought it to be incredible or useless for the purposes of justice. Whether a magistrate records any confession is a matter of duty and discretion and not of obligation. The rule which applies is a different and not less well recognized rule, namely that where a power is given to do certain thing in a certain way, the thing must be done in that way or not at all. Now, in this case, what happened, my lord? The High Court, my lord, convicted the person. He was charged with the dacoity. And the Privy Council, my lord, when it came before the Privy Council, they have said the confession statement has to be recorded under section 164. It was not done that way. It was not complied at all. Therefore, they were acquitted. So here, why I am referring this case, my lord, here you have to do certain thing in a certain manner. You did not do it. Rather, you have started the further investigation, whether police can do it. Now, as on the last occasion also I have submitted with your lordships, police has done certain mischief. Now they want to save them. This is the only way, my lord, they are trying to save them. Otherwise, if the rule is very strict, my lord, the court can do many things so far this officer is concerned. Because he may be charge sheeted in a service jurisprudence, because you know what is the law and what you are doing. You are putting a person, is it not, my lord, a illegal detention? Can you do that? Why the law did not give him any my lord locus to do that way, and he has done in that manner. Because of certain reasons, he wanted certain things I could not oblige. That's the only reason, my lord. Now he want to save himself, and therefore, my lord, this extrajudicial confession and all that he is bringing in order to save him by putting this person in a illegal detention.
Whether that 164 statement is there.
164 statement is there also, but the CD is not available. I didn't find it. Also.
My lord, I referred that in my application also.
164
Yes,
statement.
yes, that your
164
lordship will
statement.
find at page
No, copy of 164 is there.
Yes, 164 is
50
there.
and 51 in my application.
In the application itself. it-
Yes, itself, my lord, at page 50 and 51.
Page 50.
50, my lord. That itself goes to show that it's an fabricated page.
Page
Page 50, my lord.
50.
These are all stock witness.
No, these are 164 or one.
My lord,
These
your
are
lordship kindly
164
see.
statement. Lord.
Now I examine and record statement of
No, but
witnesses
164 has to be by magistrate.
by magistrate, your lordship kindly see. 164 CRPC and it's by CGM possibly. Chief Administrative Session Judge.
Who has recorded this statement?
My lord, your lordship may see the order of the session, special judge at page 47, my lord. The direction is the learned Chief Judicial Magistrate Karimganj shall do the needful for according the statement of the
No, but where is the oath?
and beg your pardon.
164, oath is necessary.
Yes,
Where is
exactly.
that oath?
No, this is the only thing, my lord, they have done. They are their whims, my lord, they are doing whatever they feel like.
Where is the,
Lordship, that was flag mark. That is in the, from the CGM record.
no, this appears to be part of CD, case diary,
Yes,
or it is because after 164,
this is a part of case diary. Hmm.
only this one is available.
Only,
Because 164
yes,
oath
Lordship.
has to be administered.
Yes, that is not available.
Who is the magistrate who is administering the oath?
Yes, yes, Lord.
His details have to be
Yes.
given.
Yes,
A format is there.
yes.
It is, nothing is there.
Nothing.
So how will we know that this is a 164? And no, there is a note under that 160.
One
That's-
note is also there, Lordship. Yes.
The magistrate never put
Hmm.
that notes.
They're construing it 164 statement because of that note.
Yes.
In earlier occasion was, that part was available, Lordship.
Therefore, case diary is very much necessary.
Yes, Lordship. But that was not sent, Lordship.
My lord, it's from 3rd of February, my lord, he is under illegal detention. Possibly your lordship may consider for interim bail.
Now. Scan copy shows that. Office note shows that scan copy is available, but this is what,
My lord, in fact, that application is not there. They haven't applied for. They did not file any leave application before the court. On the strength of the order of the special court, my lord, they have done all these things. That it indicates, my lord, if your lordship look at order dated 5/2/2024 by the special case in NDPS number 70 at page 47. My lord, they have prayed before the court, and on the basis of that, then the special court passed an order that learned CGM will take the needful and take evidence under section 164. On the strength of that, everything has proceeded. In fact, there is no such leave application. Had it been there in the meantime, it would have been, my lord, the PP would have jumped over it and produced it before your lordships.
Do you have any other submission? Mr. Bulshu?
Lordship, because I only get all this thing only, Lordship, because that is not even in my knowledge, the entire thing. Tried to find out.
Okay, let me go through the scan copies. If I feel necessity,
Well,
I am fixing a date for orders.
Right.
If I feel I may call for some additional scan
only
copy.
thing, my lord,
If it is sufficient, I will pass orders.
my lord, I will try to persuade your lordship so far interim bail is concerned. My lord, it's a total legal question is involved.
This Thursday. On Monday,
Yes.
heard Mr. S. Dr. Lanet Senior Counsel, assisted by Mr. S. Dr. Lanet assisted by Mr. Pikotaki.
Peacock.
Pikotaki, Lanet Counsel for the petitioner. Also heard Mr. K. Bosho, Lanet, additional public prosecutor. Let this case be listed for delivery of orders on Monday, on 13th, 13/5/2025.
Obliged. Possibly, my lord, your lordship could not identify him because
No,
of his
no.
cap.
No.
Even I could not recognize him.
He is identifiable even with his caps. From his smile, I can identify him.
Right.
On Monday,
Monday. Obliged.
Your lord.
Hmm.
Your lordship has already decided this matter, my lord. Before any prayer for adjournment is made, my lord, your lordship has already
you
decided.
are apprehensive that
Huh?
Ms. Dekha will pray for adjournment.
My lord, before any such prayer is made, my lord, this your lordship has already decided it. It will not even take 30 seconds for me to, page 50. I'll not go into any other details. Page 50.
No, but Mr. Kyle is not seen.
He's on Lakes in Port number 15, Lordship.
My lord, this matter has been filed in the month of February. 2 years, 10 months.
What
2
do you want
days,
to show? Page 50?
page 50, co-accused order,
Okay.
para 3, page 51. This is the case. Not even an inch more or an inch less. Your lordship has recorded, my lord, that 2 persons. I am reading para 3, 1, 2, 3, 4. Even the name of the present petitioner is also there in para 3, Javed Iqbal. 2 persons were found. One is Sanjay Kumar Shah and the other is Javed Iqbal. Sanjay Kumar Shah's bail order is this, and the other person is Javed Iqbal, who is before your lordship. Sanjay Kumar Shah granted bail in the month of January. Same, identical, absolutely, my lord. Nothing.
Yes,
And no appeal is preferred against this. This is holding the field, my lord. Therefore, I need not go into any judgments.
Lordship on
This is-
Monday, Lordship.
they had filed objection here. After going through the objection, my lord, in this case also, I don't think, my lord, because LCR has come, my lord. LCR has come and this petition was filed in the month of February, my lord. 2 years, 10 months in trial court, in high court, another 6 months. February, and we are now in mid-May. My lord, yesterday also in one case, my lord, NCB has taken time, my lord, I have not objected because there the role were different. My lord, in this type of case, if somebody prays for times for months after months, my lord, these things, my lord,
now
were,
they are praying for only up till Monday.
now, my lord, my problem is that, my lord, in Monday, today, my lord, one justice, before Justice M.R. Pathak, one matter was fixed. Now, your lordship and Justice Pathak was sitting in the division bench. I was there in court number 3. Now, I heard that that matter is also fixed on Monday. Same matter.
Next time
co-accused.
you have to be ready.
Okay, Lordship.
If Mr. KL is not available, you argue the case because the submissions are more or less same.
Yes, Lordship.
Only thing is, you have to be given an opportunity to other,
About 4 months opportunity. It's there.
on Monday,
Well, on Monday,
On Monday, Lordship.
if Mr.
otherwise she is also a competent advocate, my lord. She
No,
can-
she is ready. On Monday, she'll be
Lordship.
ready. Mr. M. Vishwas, learned counsel for the petitioner. Also heard Miss
M.
M.
Dekha.
Deka, learned counsel for NCB, who submits that as Mr. K. SC K. learned standing counsel NCB is on legs in some other court. She prays for an adjournment. Considering the ground, the prayer is made, the prayer is allowed. However, no, this is not pending so long.
Yes,
This
it
is
is
a-
February, my lord.
Only 2 dates have gone.
Well, it is filed in the month of February. We have served them copy in February, my lord.
So why it was listed after so long?
Because, my lord, your lordship was not in the bench, my lord, and as per the Supreme Court decision, my lord, the single bench who takes up the first bail application with regard to a particular FIR, all subsequent bail application will come before the same bench.
But if that bench is not available in the sea,
Now, my lord, the Supreme Court has not clarified that. That is what the registry is also nowadays, my lord. Initially, before it was only rejected bail before the same bench. Now, grant, reject both. Initially, it was only rejected bails.
but it has to be interpreted if that bench is available, if that. Okay. Considering the submissions made by learned counsel, this case is adjourned for today. Let this case be listed on Monday.
No adjournment on Monday, my lord. It's full.
Lordship, I will appear on that day, Lordship.
She's submitting
Absolutely, man.
on Monday, that is 13th of. Leftover will remain. Registry will give dates for leftover,
Only item 9, it's part and letter.
but this is not I'm not sitting, these days I'm sitting in division bench. So dates cannot be given. Leftover matters, registry will give dates as per. So if there is any prayer, you have to make it to the registry.